Well, this woman was a badass gangster rapper, an unbeatable warrior. She delivered real diss tracks in a male-dominated entertainment business. She was like the embodiment of girls can't do anything. Of course, her expressions were extremely aggressive. It was a major press conference by a mid-sized company CEO targeting prominent journalists from major media outlets, and it was much rougher and more straightforward with curses than the underground scene of hip-hop. I've seen numerous press conferences, but this was one of the most sensational in history. Let's look at some of the expressions. Those bastards, sons of... There are too many damn a-holes, haha. Do you think I stayed quiet because I'm a moron? Stop bullshitting and come at me with fists. You really have to hear it for yourself. The representatives who were next to Hee-jin, her lawyers, tried to restrain her, but it was a self-destructive situation. So, why did all this chaos happen? Hee-jin is the CEO of Adore, a label under Hybe. In 2002, she joined SM Entertainment as an employee and participated in the works of Girls' Generation, SHINee, FX, EXO, Red Velvet, and NCT, rising to become a board of staff member in 2017. Starting as a recruited newcomer and becoming an executive of SM Entertainment, a large agency known as the top K-pop company, is legendary. Now she's famous as the mother of the global idol group Newjeans, as the representative of Adore. Hee-jin, this influential figure, has been accused of attempting to seize control, which is breach of trust in business affairs, from Hybe, the largest company in K-pop. Although there have been numerous stories about the showdown between the leading K-pop companies, let's focus on the most crucial legal issues. The legal CEO of Adore is Hee-jin. What Hybe is currently most concerned about is that Hee-jin tried to seize control of Adore, which means that Hee-jin, who holds 20% of the shares with her allies, tried to acquire 80% of Hybe's Adore shares. However, the most important thing here is that for breach of trust to be charged against Hee-jin, she must have acted against the interests of Adore. In other words, even if Hybe incurs losses, if it benefits Adore, breach of trust is not established. The same applies even if Hybe is the largest shareholder. The largest shareholder is just that, and the company is a separate entity. In short, Hee-jin only needs to work for the benefit of Adore as its representative. Therefore, if Hee-jin says, I tried to secure Adore shares for the stability of Newjeans, even if she conspired to take control of what shares she holds, breach of trust is not established. Another issue is how a 20% shareholder attempted to take away 80% of the shares. Hybe seems to suspect that Hee-jin tried to attract investors to increase the shareholding. However, in simple terms, attracting investors is legal. Even mergers and acquisitions can be hostile. The evidence presented by Hybe is significant. Hybe presented the KakaoTalk conversation between Hee-jin and the management as evidence that Hee-jin attempted to seize control. In this conversation, when one of the management suggested a way to secure Adore's shares, Hee-jin responded, "Great." However, it is doubtful whether such a reaction should be considered the execution of a crime, because there is freedom of expression and anyone can express their opinions. The key is how concretely they tried to execute it or attempted to execute it. Therefore, if this KakaoTalk message is the most decisive evidence, the possibility of Hee-jin being punished for breach of trust is low. Of course, we have to wait for the results. The evidence Hybe has made public is only the KakaoTalk data that Hee-jin shared with the management. However, if additional evidence emerges from police investigations, such as Hee-jin contacting external investors, if this share acquisition plan violates contractual terms, or if the company incurs significant losses in this process, there is a possibility of prosecution or attempted breach of trust. Especially if Hybe's claim that she leaked internal contracts to secure Adore's shares turns out to be true and ultimately harmed Adore, there are various possibilities for criminal penalties, including breach of trust as well as violation of the Unfair Competition Prevention Act for leakaging of trade secrets, and so on. If Hee-jin indeed showed company documents to a shaman, she could also be charged with violating the Personal Information Protection Act. Dismissal is possible. Hybe plans to convene a board meeting of Adore to dismiss Hee-jin, and if it is true that Hee-jin attempted to separate Adore from Hybe, dismissal is possible. Wait, why should Hee-jin be dismissed if it is not a breach of trust? We should remember that Hybe is the largest shareholder of Adore with an 80% stake. The largest shareholder can do anything. The owners of the company are the shareholders. Shareholders with more than 50% ownership can naturally run the companies as they see fit. Shareholders have the authority to dismiss representatives, and dismissal of representatives is possible even if there are no established crimes, but fundamental trust in management capability has been shattered. In other words, regardless of whether Hee-jin's attempt to take over management constitutes a breach of trust, if Hee-jin's attempt to separate Adore from Hybe, as mentioned in KakaoTalk, is true, dismissal is possible. Let's rephrase. The fundamental question is what Hybe gains from attacking Hee-jin. Hybe's legal representative is the Kim and-jang law firm, the largest and most influential law firm in Korea. Naturally, they would know that establishing a breach of trust would be difficult. However, there are two main reasons why they insist a breach of trust. Firstly, to limit Hee-jin's stock option exercise, in other words, to acquire Adore shares at a low price. Secondly, to protect the rights to Newjeans' exclusive contract. According to the shareholders' agreement between Hybe and Hee-jin, 13% of Hee-jin's 18% ownership in Adore is subject to a put-back option. This put-back option essentially grants Hee-jin the right to sell 13% of Adore shares to Hybe at a predetermined price. This price is 100 billion won, which is 73 million US dollars. Wow. As Hee-jin also mentioned at a press conference, she can easily get 73 million US dollars. However, the dispute arose when Hee-jin demanded an increase to 250 billion won, that is 185 million US dollars. Wow, I should learn that negotiation skill. However, if Hee-jin is prematurely dismissed due to reasons such as a breach of trust claimed by Hybe, the amount Hybe needs to pay for Adore shares would be significantly reduced to about 2.2 million US dollars instead of the agreed 73 million US dollars. Considering $73 million and $2 million, doesn't Hybe seem to have sufficient reason to dismiss Hee-jin? As a second reason, Hee-jin sent a contract amendment to Hybe in February 2024, which included the termination right for Newjeans' exclusive contract. From Hybe's perspective, if Hee-jin gains unilateral termination rights, the likelihood of Newjeans leaving Hybe in the future is high. Newjeans is Adore's only artist, and considering the value of Newjeans' name, Hybe had no choice but to reject Hee-jin's demand. In the end, it's a fight over money and the exclusive contract of Newjeans, a global K-pop idol. And one more thing, I can see there are a lot of fights between the fandoms, especially fandoms of BTS versus fandoms of Newjeans. But you should remember this, Newjeans belongs to Adore, and Adore belongs to Hybe. Therefore, Newjeans is one of the Hybe's idol. And BTS, Newjeans, and other Hybe idols, they are just like brothers and sisters. So basically, this whole dispute is a fight over money between adults. So artists have no fault. This is your attorney, Jiwon Lee. Thanks for watching.